So the first case is Scola versus JP Morgan Chase, and we'll start there.
May it please the court, Steve Hicks on behalf of plaintiff appellant Frank Scola. I first of all want to thank the court for hearing this case and reviewing the leave application. I understand I file a lot of leave applications and it's not that often that I get here, so I do appreciate you taking the extra time and putting that into this case. I will waive the free fire zone. I'd like to maximize the time for questions. Being appellant, I think that's probably the wisest use of my time. In this case,
why wasn't negligent then not to warn about two-way traffic, if it was two-way traffic?
To warn about two-way traffic?
Yeah.
I guess it potentially could be, although I think there are would be arguments about the facts in that case where there are additional demarcations on the road and that sort of thing. I think that the salient point here with regard to the duty to warn for this particular business is that they'd been advised a number of times by the business owner across the street that this is a recurring problem of people turning the wrong way on this street. And it's that I think is really what makes this case interesting, because the foreseeability of harm, if given that testimony, makes it very clear that they knew of the problem. And if you look at the layout of other premises, there is a stark contrast between the teller lanes and the exit next in the area of the teller lanes, which is where Kathleen Scola, Frank Scola's mother, exited and turned the wrong way. If you look at the other side of the building, it's a completely different design. And it forces...
But if you focus on design, then it's a premises case, right?
Pardon me?
You said it's a completely different design on the other side. So if you focus on the design, it's really a premises case.
Well, of course, the accident didn't occur on that side of the building. What I was saying with regard to the design of the parking lot areas is they clearly knew that this one-way street was there, and that people, that by designing it a certain way, they could put them on the roadway and avoid this problem entirely. Why they didn't do that on the opposite side of the road is unclear to me. But to address the issue whether it becomes a premises case because of the way they designed the parking lot, I would say yes if you had an accident in the parking lot. You know, if they directed traffic in the parking lot and it was confusing and people were colliding, or they were like the Fowler versus Menard case, if they were, putting a cross-hatched crosswalk there where people were crossing, then you might have issues.
Why is it where the accident occurs or where the injury occurs as opposed to where the condition is, the location of the condition?
Well, I don't think it's necessarily, I think it is true in this case that the injury occurred off their land. There's no question about that. She turned right, she drove a short distance. It occurs on the road. It's not even, technically, it's not even adjacent to her property. But the real salient question here is, where's the dangerous condition located? What is that dangerous condition? And the dangerous condition in this case is the traffic flow on westbound Michigan, the one-way traffic flow. And the defense in their briefing focused a lot on the complaint and whether the allegations seemingly, and I think the Court of Appeals majority in particular did as well, focused on verbiage in the complaint about the signage, the warnings, et cetera, things that, are obviously on the premises. But I think they confuse two important concepts there. They're confusing the dangerous condition with the means to educate people about how to avoid that condition. It's basically tantamount to saying that a warning that's on a dangerous product and the dangerous product itself are the same thing. Well, clearly they aren't. The product itself is dangerous in its own right. What the warning does, or a lack of warning, is probably more likely the case. What the lack of warning does is it increases the risk that someone's going to be harmed by that already dangerous product in the example I was just using. or in this case, by the dangerous condition, that's not on the land. It's not on the defendant's land. It's beyond the boundaries of their land.
Is there anything, you mentioned this before, but I guess I wasn't aware you're making this type of argument. Is there anything about the condition of the driveway that enhanced the danger in some way or obstructed somebody's vision? Or is that an element of this case, or is this solely a lack of signage case?
Obstruction of vision, no. I did note in my briefing that there is a tree, and from the pictures, it's unclear to me whether the tree is actually on their land or in the right-of-way or not. But that's not something that was alleged below. So I think it's accurate to say that this case really is about the signage and or lack of signage. And if I could, I'd like to just discuss what they did with regard to signage here, because it's not simply a lack of warning signs case. I mean, the flow of traffic was set up in this building to go on that side of the building towards the teller lanes. People could use the teller lanes, or they could go around the teller lanes. And there are two key things that the bank has done on their property. They put a blue sign up, says exit or exit only, blue exit only. And they also put pavement markings on the ground. And it's important because the pavement markings, it's a straight arrow. It doesn't give you any indication that you should turn left going. It wasn't a curved arrow to the left. So there's two things they did there in terms of assuming the responsibility of directing the flow of traffic in their parking lot. They did other things on the west side of the building, and they did them very differently, and I'd say that enhances our argument that they knew of the potential problem.
Let me ask you this. Are there any cases from any jurisdiction that recognize that the property owner has a duty of reasonable care to include a duty to post a warning sign of traffic conditions on the public roadway? In other words, isolate all these other variables, because I see that there's other cases that involve vision obstructions or other things that the landowner did on their own property that may give rise to a duty to warn of the kind that you're alleging. But I have not found any cases that say that the duty to warn exists independent of anything on the landowner's property that contributed to the danger in some fashion.
You know, I don't know that I specifically looked for that. I know that defense counsel has pointed out that there isn't a statutory duty to put a certain type of signage in your parking lot, and they pointed out also that obviously the road authorities have some responsibility for doing that. But I think it's neither here nor there, because the duty to use due care, if this is an ordinary negligence claim, and we contend that it is, the duty to use due care is triggered by basically four things. The fact that there's foreseeability of the harm, that the burden on the defendant is very slight to do so, and that the nature of the risk presented is significant. The fourth thing is the relationship of the parties. In this case, the relation of the parties is not my strongest argument.
I mean, if the argument
but
is that
foreseeability of harm is.
If the argument is that basic negligence law leads to the conclusion that this type of duty exists, wouldn't I expect to find one case since automobiles were invented that recognized that?
I would think so, and I haven't specifically researched that, but I've thought about it in this context. Maybe it's difficult because, I think it's difficult in some ways in this case because we're talking about a one-way street. And, you know, we encounter one-way streets. There are one-way streets in downtown Lansing. Our focus, of course, has been on the fact that they knew that this was a problem for people exiting their particular business, and then that triggered the duty. But let's put it in a slightly different context. I mean, if you had a business or owned land and had a business that abutted a lake or a cliff or something of that nature, and there were roads alongside of it and roads leading to it, would we really say that there was no duty to advise people driving in that area, don't turn left, or in this case, don't turn right because you're going to end up going into the lake, or you're going to end up going off the cliff. So I think if you put it,
So the issue is, how dangerous is the situation or the conditions? Is that what you're saying? In other words,
I think that's an important factor. That's the nature of the risk
on the
presented.
one side of the spectrum, they don't have to warn people that it's raining outside and that they should wear a raincoat or else they're going to catch cold, right? They don't have to do that. Or if it snows, they don't have to warn people that the roads might be slippery or else they might get in an accident. So, in other words, there are some things that we sort of charge people with knowledge of or think that people should be aware of in this world. And I guess my question to you is, assuming for the moment that you make a valid point, that if the danger is sufficient enough or extreme enough that there might be a duty to warn, Justice McCormick always likes to use her shark pit example.
Dude, don't
We could put
upstage
some
me. Let
sharks
me
in the lake.
save the shark.
All right, so
Sharks in the lake,
forget I
too.
said that. But why is this case, why is the traffic laws, the speed limit, the direction of traffic, et cetera, why isn't that more like in the nature of something that we charge people with knowledge of, and we want people to be responsible for knowing, and we expect people to know,
Yeah.
so that we don't have anarchy on the roads, number one. But number two, this is just sort of imbued in the way that our society works, that people
Yeah.
are expected to know the rules of the road before they get behind the wheel.
I think that's certainly true, and it kind of goes to the question, the first question I asked trial counsel. I didn't handle this case in the appellate courts or in the trial courts, but the first question I asked trial counsel in this case is, so are you saying that everybody that has a driveway that abuts a one-way road has to put up a sign? I think that's really where the question gets to. And I thought he had a good response to that. I said, no, absolutely not. I'm not saying that at all. But I am saying that when a business owner across the street repeatedly comes in and advises you, hey, people are turning right all the time. It's really scary. They nearly have crashes, and there have been crashes. When someone testifies to that, and
But your sign, everyone having a sign question is something that worries me, because if somebody leaves, this doesn't just apply to business owners, this would apply to anyone who owns a property, right? This could apply to my house.
it would.
my
I would say
driveway.
I would say a business owner is different because, of course, a business owner, and this goes to relationship of the parties, not status of
Well,
the
that-
person on the premises, but the relationship of the parties. They open up their business. Hey, come in.
Well, let's say
drive through.
I'm a nice person and I invite people over to my house. The point is, if somebody backs out of my driveway and people drive too fast on my street and they get in an accident, do I have to put a sign at the end of my driveway that says, look out, people drive over the speed limit on my street, which unfortunately they do, and I've complained to the police chief about it?
Potentially you might. It sounds very similar to me to the Blackwell versus Franke case, where we're dealing inside the home, what the duty was to a licensee on the premises. So I think it's similar in that respect. But I think the fundamental difference is with a homeowner, they're not a business owner. Their relationship to people that come on their premises for whatever reason,
But
use
the
the
duty of
ATM.
care would be the same, wouldn't it?
Pardon me?
The duty of care would be the same it's
If a
unclear to-
duty is triggered, the duty
I'll
probably
say
would
this,
be
it's
the
unclear
same.
to me how the relationship plays into the ordinary negligence case as opposed to a premises case where you have a heightened duty
Mm-hmm.
based on a special relationship. When you get out, if you say it's not a premises case and the relationship still matters, it's not exactly clear to me how that factors into it.
I don't
But it
think
seems
it's.
to me that it's the same if you have a commercial business and you open yourself to the public as if you have your home and you invite people over. You're going to say that relationship comes out somewhere close to the same, right?
I
There-
think you're.
Is there a difference, regardless of type of landowner, between where they don't put any sign and here where there are signs, a sign, an arrow, a straight apron as opposed to something like that, that makes it, you have undertaken to do something which you may have a duty to do with reasonable care, which may be different
That is
from no
that is
sign.
most often where you see the triggering of a duty to use due care, is where there is an undertaking, is often the word. In the complaint, the plaintiff's attorney used the words, assume the responsibility, and that's how they did it in this case. They did put a sign, they did put the pavement arrow, they put nothing else, kind of lulls you into a sense that they can't. But to answer your question more directly, Justice Viviano. I think the duty of care, if a duty is established, a duty of ordinary care is established, what is due care would be a jury question ultimately in terms of what you have to do. Whether a homeowner has to do the same thing a business does.
Let me ask you this, if we think of this person, because you're running out of time, as a licensee, would there be a duty to warn, or would we say this person had reason to know this was a one-way street? Because you're charged with knowledge of the rules of the road, and this person drove across this street before she turned into the bank in the first place.
Assuming that the court finds that this is indeed a premises case and concludes that.
Well, what
that
if
the
I
person
don't,
is-
and it's ordinary negligence, but I'm still trying to figure out how the relationship of the parties plays into it? And this
Well, it's just
person-
one factor. And if the relationship with parties, I have basically admitted, is not the strongest factor in this case. Foreseeability is, burden on the defendant is. Those can create the duty on their own. Relationship is not a litmus test.
Let me ask one last
Certainly.
question, and I'll be quiet, I promise. Is there any evidence in this case that sometimes these, I haven't been to this location, I don't know much about it other than what's been in the pleadings, but, some of these cities changed two-way streets into one-way streets, 40 or 50 years ago for traffic flow, urban revitalization, whatever the reason was, which I think was a big mistake, but in most cities, but that's how they are. And sometimes these properties pre-existed those locations, and so that would explain why the driveway opens like a normal driveway as opposed to one that sort of shunts people out in a certain way. And I've seen some cases where the creation or moving of a driveway could be the type of affirmative act that you seem to be suggesting we might think about. Is there any evidence that this driveway was moved recently without taking into account all of these safety concerns?
This driveway, I don't believe so, and I don't know the length of time that it's been one way. It is one way only in that 3-mile stretch in Wayne. But if you look to the other side of their building, they clearly made modifications on that other side of the building to take into account for the one-way street on that side. It curves you out. You have to exit to the left. So that's all I can really say. The other side, the side that she exited from, this case is old. I mean, it happened in 2003 and was brought when Frank Scola turned 18. So it's been that way for a while, and it's been changed slightly, but it's basically the same even today.
Counsel, you said a few moments ago that we should be concerned when someone is lulled into, I think you used the word lulled.
I did.
Lulled into a sense of security by something that the defendant has done or not done. I'm just a little bit concerned about that theory and the slippery slope that might be introduced by that theory. What exactly should this court be concerned about in terms of your lulling theory? When is that lulling theory introduced into a situation?
I don't know that I've articulated a lulling theory. I did use that word in describing it. In some ways, I think it's similar to what this court faced in the Fowler versus Menard case, where you've got a crosshatched crosswalk in front of a business. So and the question became, should the person exiting Menards, I believe it was, should they feel some measure of safety in doing so? I haven't really articulated that in this case as a theory, but I think it's part of the assumption of responsibility that they put signs down and point the arrow straight, not the curved arrow. They say exit only. They don't tell you anything else. All of those things trigger the duty to use due care in doing so and create a jury question as to whether that duty of due care was violated.
Would the defendant have been better off than not having any arrow at all?
Probably. I can't remember whether the experts got into this issue, but I think the fact that the arrow was put down and it points straight rather than left suggests a lack of concern for what direction you go.
If there's no arrow at
as long as
all-
you go out there.
If there's no arrow at all, isn't it possible that then oncoming traffic will enter because they don't see an arrow pointing outward?
The arrow is actually all fully on their premises. So
I understand,
I don't
but
let
as-
vehicles from the road.
As a driver
see it.
comes up trying to get into the bank and they don't see an arrow pointing out, they might enter thinking it's an entrance.
Yeah, I think they'd already be, in this situation, they'd already be in there. But I think that what you're really saying is if they had done nothing, if they put down no arrow, if they put down no exit sign, if they'd really done nothing there, would a duty be triggered? I think I would have a weaker argument that they had undertaken the responsibility, assumed the responsibility for directing the flow of traffic in their premises. They might have other problems with that, such as, you know, if they had a history of collisions, people pulling into their business and hitting people exiting the teller lanes, well, then they'd have a different problem of sorts. But not one that's not easily solved by a simple arrow.
Thank
turning
you.
left.
Thank you, counsel.
Thank you very much.
Morning, may it please the court. My name's Robert Kamenek. I'm here with trial counsel Barb Marzano. We represent the Chase defendants. Your Honor, I just want 30 seconds to do a quick introduction, and from there, fire away if you please. In 2013, one of the justices stated an opinion that it's sometimes useful for courts to emphasize that common sense as well as precedent recommends a particular course of action. That was your Chief Justice in the Bailey case. I think that is well stated and applies to this case because this is such a case. This is a case that involves common sense. When I was preparing for the argument, believe it or not, what I was most struck by is when I read the response, the lower court response to the motion for summary disposition. And it's hard to escape the notion that even plaintiff's counsel thought this was a premises liability case. And why is that? Because throughout that response, and I understand it's not the same as the complaint, I can get to the complaint, talking about a single directional arrow that should have been on the premises, that there was reckless disregard with respect to activity on the premises. The dangerous condition is on the premises. That was stated in the lower court. Dangerous condition is on the premises, which is somewhat different than the argument that you see in the appellate briefs. And I thought even more importantly, Chase Bank had put on notice. Notice is an element of a premises liability case. Of the dangerous condition on its premises. Once again, the dangerous condition on the premises. That was the position taken in the lower court. And that Chase Bank had possession and control, yet another element of a premises liability case. So if you were to take that as talisman of the nature of the action, I think you would inevitably conclude that this is a premises liability case.
But counsel, how do you address the fact that the ultra-hazardous situation occurred off the premises?
In what regard, Your Honor?
In the fact that you had a collision and an accident that happened off the premises. I mean, the injury took place off the premises. So the actual ultra-hazardous situation, it's not like there's a hole in the parking lot or something that's confined to the premises. The injury in question took place outside the premises.
Your Honor, first and foremost, the defense would suggest that this is not an ultra-hazardous condition vis-a-vis special aspects, if that's where the court's going, because I don't think there's any special aspects here. But the dangerous condition, as alleged, is the fact that you exit a parking lot into a highway. But for that, there's no cause of action. But for that, there's no activity, there's no steps taken by Chase that would even affect this case. The duty has to somehow arise from something that Chase did or didn't do. And so in my view, Your Honor, you have to keep going back to the lack of signage on the premises. This case is all about lack of signage.
What do you do about the argument, or could you address it, that it's not a lack of signage case? There was signage, but that the signage was misleading. And I understand the argument that you make, that it was pled and argued as a premises liability case. But assuming, humor us for the sake of argument that we think it's preserved or whatever, that we have to get to the case of an ordinary negligence claim, do you believe that there is, or there can be, an ordinary negligence claim under the facts of this case, regardless of whether you think it was pled?
I think the answer to that is no.
Okay.
The directional sign, which was on the pavement that they're talking about, just pointed out. I don't think that's sufficient for an undertaking. I'll give you an example, and I think that Justice Zara got to this if I understood his comments earlier. People are still going westbound down Michigan Avenue. That sign could equally apply to somebody saying, don't pull in. So it's not per se just an undertaking with respect to people that are exiting the parking lot. Also, it's my understanding the parking lot was one way in any event. So I don't think it rises to the level of an undertaking.
Counsel, I think what Justice Bernstein was saying that, I don't want to, I think his question was not about special aspects, but rather whether the plaintiff pled it as premises or not is an important question, and maybe that's another reason why your client should, if in fact it was only pled as premises, your client may have a different reason for not having to proceed, or for winning. But more importantly, I mean, I guess your answer to his question is the dangerous condition on the land is the lack of signage? Is that, what is the dangerous condition? How theoretically could this be a premises case?
Well, the danger that they're alleging arises from the lack of signage on the property.
So
But for the lack of,
danger arises from a lack of signage, but that's not, premises liability, of course, is, we have this heightened duty for property owners because they're in the best position to fix a problem on their land, right? That's the whole idea. But a property owner is not in a great position to fix one-way streets. In fact, I don't think they even have the authority to fix one-way streets. So I guess I'm struggling to see how this case could sound in premises, putting aside whether it's been only pled in premises, which I defer to you about, or defer to you both about. I don't want to get into that right now.
well, let me start in reverse order. And we have briefed this, Your Honor, even assuming it's an ordinary negligence case.
Yeah.
There's no duty. And
So that's, I think, where the interesting action is, and let's, he tried to use my Shark Tank, but I feel like, you can always come up with hypotheticals on either end of any ordinary negligence hypo I can give you a hypo on one end that would, I think I could get everybody to agree there's no duty, and I could give you a hypo on the other end, all in the same area to get everybody to agree there is a duty. So, of course, if your exit out of your building has a path to a sidewalk, but the sidewalk turns out just to be a mirage covering a shark tank, but you think it's fun because it's fun to see who can, survive in a shark tank, you would probably agree with me that I have, that if that's my property and I did that, I painted a mirage over a shark tank, I have violated my duty of care to my fellow citizens who die in the shark tank, probably.
I believe I understand your point.
Yeah.
And bear with me if I don't, but at the end of the day.
My point is only there's a crazy hypothetical under which an ordinary negligence claim lies, depending on how I'm not saying it's your case. Would you agree with me there's a crazy hypothetical upon which an ordinary negligence claim lies?
I think that people can put together hypotheticals that would support, arguably support a court saying there's an obligation. If that's the point, yes.
And then let me give you one on the other side. I think Justice Viviano had a bunch of good ones. I don't think, if it's raining outside and somebody sues me because I didn't tell them that they should wear a hat or they might get a cold, that anybody, I could poll everybody in the room right now, raise your hand if anybody, no, don't, I'm just kidding. But no, I could get everybody to agree that there's no duty to tell people it's raining outside and they have to wear a hat when they leave the bank, right? I mean, that's, you would agree?
I would agree, but what I would suggest is that you've hit some extremes there.
That's the point. That's my point. Extremes are helpful because they just help us identify whether it's possible there can be such a claim or another claim. And so in this case, whether a one-way street where there's been notice, I grant that the plaintiff has on its side, in the four-factor test for determining a duty, it has foreseeability, it has, it's inexpensive to fix. It has a few things on its side. On the other hand, you might say a one-way street is something everybody is supposed to pay attention to. We're taught, to pass driver's ed, you have to, remember that a white line is a one-way street, and maybe that trumps all the other factors. And the question is whether this is more like a shark tank or a rainy day.
Well, I think it's more like a prohibition under MCL 257.641 of going to do what the municipality should do. And I think that enters into, and we've cited that in the brief,
If you want permission for signage such as that, you have to go literally to the State Highway Commission for this. So there's something
So
additional
I think that's a
here.
great factor on your side for making this more like a rainy day than a Shark Tank. But so I appreciate that. That's a helpful, I think that's a helpful
But at
fact.
the end of the day, the question of duty is for the court. And I would agree with counsel to the extent that if you go to ordinary negligence, which I don't think you can, but if you go there on this particular fact, it does involve matters of public policy. I don't shy away from that at all, Your Honor.
Yeah. No, you might have
and-
you might have you could have stood up and said, doesn't matter if it's ordinary negligence, there's no duty. That's a very,
And I think I did,
decent
but
argument for you.
I'll adopt that position. And I agree. So, if you think, and it's in the brief, I gave you, think about the notion, and I don't think this is a far-off hypothetical. Think about the notion of the 60 traffic signals that I put forth in the brief. And I consciously listed them down the page to make the effect. So somewhere down the line, a private landowner, whether it be somebody who's residential, as brought up by Justice Viviano, dealing with their social gas licensees, whether or not they're private landowners, and you're talking about bringing on contractors where they would arguably be invitees, so you've got different standards there. You would have to go ahead and be aware of those situations, 60 of those, and decide whether or not you have to do warnings or put up signs. I would suggest strongly that that goes well beyond an obligation that should be put on any landowner. I don't care if it's a business or a private landowner. And
I mean,
duty
you
is a
could argue
question
that
for the
all
court.
traffic, cases are rainy day cases and not Shark Tank cases, but you probably don't want to, because there's going to be some, you could imagine a case where the white line is completely, dissipated, and the bank CEO sits in the window every day and watches, person after person after person get, into head-on collision, and then everybody might agree, okay, maybe in that case they should make the yellow arrow that points straight, point left, But
I understand. The only thing I can do, Your Honor, as a litigant, is bring it back to home to these facts. And at the end of the day, there was testimony that she was aware that it was a one-way, at least saw the sign when she was going southbound on Wayne, saw the line when she crossed westbound on Michigan Avenue, was aware of that. And at the end of the day, she's 40 years old. She's been presumably driving for 20 years, just to make the point with an emphasis. And you should be aware of traffic laws. Otherwise, quite frankly, that's why you've got that license in your wallet or your purse. You are charged with knowing the laws of the state of Michigan vis-a-vis traffic. So in that regard, I don't suggest to the court it's not a dangerous condition. I mean, pulling into traffic, if pulling into traffic is a dangerous condition, then we've got a whole bunch of lawsuits that are going to be filed in Michigan someday. And that's a problem. And really, at the end of the day, there's got to be some responsibility.
Well, but isn't that, it's not that dangerous, everyone can file a suit because traffic is dangerous. It's, did the defendant violate or fail to use reasonable care given that dangerous condition? I mean, we know that traffic is common and they are dangerous, but it is dangerous, right? I mean, a head-on collision, driving the wrong way down a one-way street is still dangerous. Isn't that, I mean, the weighing it, and it's not a absolute or strict liability, it's a standard of reasonable care, right, which juries evaluate all the time.
But I understand, Your Honor, you're going to the standard of care, and I understand the point, but you don't get to the standard of care if there's not a duty in the first place. And that's the law in the state from this court. And so I'm suggesting that you don't have a duty in the first place to be warning about traffic situations. Here, is it reasonably foreseeable, notice or not, that if people are going to turn the wrong way in a one-way street? If the argument is it's reasonably foreseeable in this circumstance because you had notice, at least I understand that. This gets to, at some point, it gets almost Paul's Grassian, that you've got an unforeseeable plaintiff, unforeseeable sequence of events. But more importantly, I just keep going back to the point I made earlier. If you have to start giving warnings in these situations, candidly, it's above and beyond. It deals with the standard of care. If there's a duty, I don't think there's a duty in the first place.
With respect to traffic, would you agree that a premises owner has an obligation to use reasonable care so as not to cause harm to somebody off the premises? You're just saying, again, like, whatever, putting your driveway on the edge of the Grand Canyon and, just saying good luck, or the Shark Tank, whatever it may be, is that, would you agree that there is a duty to use reasonable care, and your position is it's just not present, given the traffic and given the facts in this case?
It goes back to the predicate question that this court asked. Is it a premises liability or ordinary negligence? Because if it's premises liability, that liability is based on your ability to do something about that hazard, possession and control. And you do not have possession or control of a situation off your land.
So you
never
don't
get to
think
that
it's a
point.
premises liability claim?
Excuse me?
You don't think it's a premises?
No, I do think it's premises liability. I think this is a premises liability case, and when you're talking about an alleged danger to take the plaintiff's argument, that's off-site, you think about the theory, what can a premises liability owner do? They don't have possession and control to affect that situation. They can't go fix that
If they
situation.
don't have possession and control, how is it a premises liability case then? You have to have a condition on the land that causes harm and a defendant that has possession and control,
So they can fix it.
so they can fix it.
That's
But
right.
if you have neither of them or only one of them, you don't have a premises liability case, but you still, as a person or business or a defendant, have a duty to do what you do with reasonable care, correct? I mean,
I
you have
understand your
to, you have certain duties with respect to criminal acts of third parties on your property.
Right, so-
You have a duty not to physically cause harm or actively cause harm to somebody on your property. That doesn't have anything to do with premises liability.
I agree.
Towards 101, first day.
If you have, I agree. And if you have a situation where there's an over contemporaneous activity going on in the premises, I understand how it's ordinary negligence, but you simply don't have that here. You have a static situation in which the claim arises out of the premises. So
Thank you very
I've
much.
got to end it that way.
Thank you.
Thank you,
Case
Your
will be
Honor.
submitted. Thank you.